A consent decree was filed Friday between the U.S. Department of Justice and the VI government to settle a lawsuit alleging the territory has violated the Uniformed and Overseas Citizens Absentee Voting Act, which says
45 days prior to any election, all ballots related to that election must be forwarded to military and overseas voters.
Absentee voters who fit this requirement have the option to request a ballot by email, fax, or express mail. Then the ballots have 45 days to be transmitted, marked, and returned. But in the case of Saturday's primary,
45 days prior to that date would have been July 25th. On that date, I would not have even known who would be running for office.
That's because local law in the case of Saturday's primary did not require candidates to file petitions until August 14th, therefore failing to meet the July 25th federal deadline. Abramson says the consent decree is an immediate remedy, but it's still up to the legislature to change local law for the 2014 election.
The real work to be done is to change all of the dates that precedes the August primary.
Abramson says they've already begun to implement a number of changes in the consent decree. However, in order for that agreement to be valid, a judge must sign off on it. But today's hearing with Judge Curtis Gomez instead brought up a lot of other concerns like a lack of funding and an unstable website. After a brief recess, both parties agreed elections needed a special fund to address expenses like express mailing for absentee ballots and an operational website. $9,100 was decided as sufficient, although no one was sure where the funding would come from. Also, Abramson agreed to inform the legislature of remedies to the VI code. There were no objections, and both parties agreed to work together. For News 2, I'm Erica Bivens.